All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the State Court Administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The Clerk supervises the Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the State Court Administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The Clerk supervises the Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The Court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website.
Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good morning. Please be seated. We are here at the time set for oral argument in file number 2025-0370, State of North Dakota versus Joseph Anthony Hernandez. Sitting today are Justices Jared Tufte, Justice John Jensen, Justice Douglas Barr, Justice Mark Freese, and I am Lisa Fair McEvers. Arguing this morning is Chad McCabe for the appellant, and I see, Mr. McCabe, you have reserved 10 minutes for rebuttal. Yes, and counsel for the appellee, the State of North Dakota, is Daniel Vondracek. Good morning, Mr. Vondracek. Mr. McCabe, you may proceed when you're ready.
Thank you. May it please the court, member justices, and Mr. Vondracek. So before I begin, I know in the last case, I believe, regarding the right to an attorney there, I think the court may have still believed the statute on the right to an attorney was still, there was problems with it. That has been fixed. So Senator Hogue, at my request, made that change, and so that statute that we're dealing with today has been corrected. So it now does read the way it used to, where the defendant the accused had the right to speak to an attorney. So just so the court understands that, we don't have any misunderstandings of the statute anymore. Anyway, as to that statute, I think this court really has lately three significant cases on this issue that affects the facts of my case today that I'm presenting to you. I think for starters, you know, the Cudmore case that I cite in my brief, where this court probably, at least the way I read Cudmore, would have found that there was a statutory right to an attorney activated, but for the bombastic and swearing from Mr. Cudmore. And so I think this court found as a matter of public policy that this court was not going to activate that right. Compared to this case today, of course, is the case where there absolutely is no bombastic, and in fact, the judge wrote an opinion how courteous and my client was to the officer and how they got along.
Didn't the court also, though, find that there was no request for an attorney?
That's what the court found, yes, Your Honor.
Can you point to any part of the record that would make that finding clearly erroneous?
Well, it's a matter of law, I believe, for this court.
What was the request? I mean, from everything I've read is I got a paid lawyer. How's that a request for a lawyer?
Well, and then he said he was going to call his lawyer.
I'll call my lawyer as soon as I leave from here.
Yes.
Is what I understand it, the statement was.
Yes.
Again, how are either of those a request for an attorney?
Well, I
have
think
an attorney and I'm going to call him later.
Well, Justice Barr, I would argue that under the Bailey precedent, the Bailey is the big case, where this court has hung on the right to speak to an attorney, and the court doesn't want to get into fact-by-fact variations of that request. I would argue that in this case, the mere mention of an attorney, as Bailey says, the mention of an attorney activates that right.
But doesn't Bailey say in response to a request for chemical testing? So, for example, had Mr. Hernandez said, my attorney died, I'm going to his funeral next week, would it be logical to say that he's invoked his right to counsel? This was not a conversation that occurred in response to a request for chemical testing. It was simply dialogue between the defendant and the arresting officer, as I read the record.
Yes, I would argue that in Cudmore, there was no mention to talk to an attorney about chemical testing either, but this court nonetheless said that had this happened in a less bombastic fashion, that may very well invoke the rule. And as I see Cudmore, other than all the F-bombs and whatnot, there's a similarity to this case with Cudmore.
So it's your client's position if the word attorney or lawyer is mentioned at any time during the conversation, that's a specific request for legal counsel?
Well, I think one thing I'm asking this court to consider, and it's mentioned quite heavily in Washburn versus Levi, and Skobodzinski. I'm going to misspell that. But those are the two big cases. This court has dealt with this issue as of late. Both of those cases talk about the 2-hour limit, the important 2-hour limit. And we know in this case we've got well over an hour to get chemical testing because the officer has written them down as a refusal, and there's still ample time to get a chemical test. So under this situation where the Bailey mention of an attorney is, even if it's done, as we say, sort of ambiguously, and I would agree it's ambiguous, but without clarification, without letting the person, here's the real issue I'd like to present to this court about this topic, is that these people simply do not understand they're being charged with a crime of refusal unless they're told. In this case, my client was never told he was being charged with a crime of refusal. And it's very sad because these people, they don't understand. And you know, we write these laws and we have these laws applied to these people, but they're simply not understanding that when they leave the jail, they're going to be charged with a crime of refusal. You know, prior to 2013, officers went out of their way to get a test because it wasn't a crime. Now that we've made it a crime as of 2013, once those officers get the refusal, they don't bother to do anything. Most of them could care less because now they've got a DUI conviction, probably just because they got a refusal.
So somehow law enforcement should become an advocate for the folks that they pick up if the word attorney is spoken?
Well, the thing that bothers me, Justice McEvers, as we apply all these laws to the facts that happen day in and day out in North Dakota, is that, you know, with these people not understanding it's a crime. And there was a time recently where 39-2001, the officer had to tell them it was a crime under that implied consent advisory. That was removed from 39-2001 based upon a promise, I believe, to the legislature in committee meetings, it's all in the committee minutes, that they were going to be told it was a crime anyway under 39-0801, the DUI statute. And it is in there. This court has interpreted that section a little bit different than we were hoping. But there was a promise made that these individuals will be told it's a crime. Anyway.
Shouldn't fulfillment of that promise come through
What's that?
legislature, right?
What's that?
Shouldn't fulfillment of that promise come through the legislature? You're asking this court to do something that the legislature has declined to do?
No, but what I'm asking this court is when we have an ambiguous mention of an attorney, and it's so important that these
I don't understand
people.
how this is ambiguous. There's in no way an indication, I want my attorney. I will call my attorney later. What is ambiguous about that?
Well,
I'm going to call him when we're done. Okay, go ahead.
I would argue because this person clearly has no idea he's about to get charged with a crime of refusal. And he's going to talk to his attorney about it later. And if he were able to talk to an attorney at that moment, he may very well find out that you better take that test. And we've got about 70 minutes left to
You
take
can make that same argument for someone who never even mentions an attorney or a lawyer. You could say they didn't understand, so they should have been, the officer should have given them that
True.
opportunity, even though they never even used that word.
Well, Washburn, the guy said he wanted to talk to his father. Somehow the hearing officer viewed that as a right to speak to counsel, and this court in Washburn found that the right was activated well after the person said he wouldn't take the test. And so I've got a much stronger fact pattern than Washburn as far as what was actually said. I mean, he just simply said he wanted to call his father. I don't know how that got viewed as an attorney, but it did by the hearing officer. But as we look at these cases, members of the court, it's this 2-hour window. It's so critical yet. 2 hours to take a test. In this case, we know we're at the jail. The record reflects, even from the judicial opinion, that the intoxilizer machine's at the jail. I mean, they got 2 of them there. But so there's over nearly 70 minutes left out of the 2 hours to get a test. He's at the jail. He's getting booked in. Similar, I would argue, to Washburn. Washburn was getting booked in that case. And he mentions his attorney, and nothing said about it. Nothing at all. It's just, And I just think under the circumstances where it is so critical that this person be made aware, if possible, that he's about to make a terrible mistake by refusing this test.
It seems like the person, the legislature should require that you may request an attorney and you should do so. I mean, they're leaving it up to the person in the statute, right? They're not saying that the law enforcement has to advise them and you should do so before you walk out of here or there will be consequences. It's how far does the advisory go and how far does the statute need to go?
Well, I don't know, but I want to fix 390801, so I'm hoping we can do it this next session so that somehow the person's told it's a crime. Now, many officers do. God bless them. Many officers take that next step and tell them it's a crime after they refuse. And oftentimes that's all it takes to get them to take the test.
So I think, Mr. McCabe, that sometimes it's the arguments that various attorneys come up here and make to us about what should and shouldn't be said in the advisory and attacking the advisory and how it's given that leads to officers perhaps not giving anything they're not required to do because there have been appeals up here making those arguments. They said too much.
Well, I think I had the case where you ruled that they don't even have to give the advisory anymore. I regret to have that decision, but I think that kind of gutted out even needing to tell the person about the advisory anymore. Unless it's a refusal, then suddenly it does come into play, and I probably have those cases. But yeah, on the people that take the test, it doesn't matter, I guess, what they say. But it is, we're dealing with a refusal here, and we're dealing with a very concerning issue where the person is accused of refusing the test, not probably even aware they're being charged with a crime of refusal. Because the advisory as given today just says they're going to lose their license. Doesn't say anything about being charged with a crime. It just simply says to them, you're going to lose your driving privileges. They're never told they're going to be charged with a crime. So I think that's very sad. I mean, they used to be told they were going to be charged with a crime, but we took that out. And then the legislature again was promised that nonetheless they'd still be told. And that's not the case. I would say 20% of the officers tell the person it's a crime after they say no. The rest could care less. So again, my greatest strength, I think, is the Washburn case, where it's at booking, where the person mentions an attorney. But then we go on to the Cudmore case, where this court even basically, at least I hope that's what this court was saying, was that the right would be activated, perhaps, if it wasn't so bombastic. And my gosh, I have the perfect case here. The judge is saying how, they got along, my client was courteous. The officer even took him home. I mean, it's a very good case that goes against the terrible, terrible facts of Cudmore, where the person was extremely disrespectful, and this court, as a matter of public policy, just was not going to invoke the right to statutory counsel. So that's essentially my issue. Is there any other questions? Okay, well, thank you very kindly, members of the court.
Proceed when you're ready.
Thank you. Yeah, good morning to the court, if it pleases the court, and Mr. McCabe, counsel for Mr. Hernandez. Was Mr. Hernandez denied his right to counsel? That's kind of the question today. The state would posit that he didn't even make a request, and I don't mean to sound flippant or conclusory when I say that. If we look at the statements, there's two core statements that he made during this entire interaction that lasted almost an hour. It starts earlier than the statements, though. Like I said, both were made near the end of this interaction with Deputy Bugbee. At 10 minutes, 50 seconds in the timestamps for that video the state submitted, he's been read as consent advisory for the PBT. He refuses that. There's no indication Mr. Hernandez doesn't understand the advisory, nor is ignorance of the law an excuse. Then at 15:13, we have yet another consent advisory read by Deputy Bugby to Mr. Hernandez prior to his refusal of the intoxilizer 8,000. Again, no indication whatsoever that he didn't understand, that he might want some help, to talk to anybody. The context is very important here, I think, and the court's picking up on that already. Is paragraph, let's say paragraph 13, for example, in their Hernandez brief, talks about his rejection of the intoxilizer. And then if you move on to paragraph 14, here we have, he makes a call. He does, and Deputy Bugby assists him in that. He calls his girlfriend, though, to pick him up, not his attorney. And I think this can distinguish Washburn, in that in Washburn, I think it was that he just wanted to make a call. The deputy wasn't even sure he wanted, or who he wanted to call, whether it was his father or an attorney, or both, which I think is ultimately what the deputy, in that case, ended up on, just as I suppose an abundance of caution. Here we have him knowing full well he can call his girlfriend, and he does as much. And then, of course, the statements we're all interested in at 47:10, we have the statement there. I think, I call it a statement because I think that's what it is. I don't want to paraphrase. Let me quick look at it here. Yeah, he says, quoting, "I got a paid lawyer, so I ain't worried about that." To me, that indicates just the mention of an attorney shouldn't trigger anything that's going on in like cases like Bailey. The bright line rule, I fully understand, and that's why I said I don't want to be flippant about this. But I take that as a statement, and it's closed in nature in my interpretation. He's just saying, I got an attorney, I'm not worried about the consequences of the refusal.
So, Mr. Vonderchuk, we've been arguing a lot of the cases that derive from the Kuntz decision. And that's purported to derive from 290520. Does that statute in any way limit itself to DUI offenses? The statutory right to counsel that this court has described?
I wouldn't think so. I guess considering the constitutional importance of the right to counsel, I wouldn't consider it limited there. I don't know that we don't even get there here.
Right. So I'm wondering if an implication of the decision we're asked to make here is that any person arrested for any offense, the statute uses the term all cases, would have a right to assistance in discussing their options with counsel after they're arrested, just by stating that they have a lawyer. What rule could we possibly offer to narrow that, in your view?
I guess, yeah, I guess I'm kind of relying on a reasonable interpretation of the state. Like the magic, we shouldn't be able to just say attorney and that automatically attaches, or then, follow up, because it was I don't think it was ambiguous at all. He just said he had one. So I don't know that Deputy Bugby, in normal conversation, would have needed to say, did you want to call him? Because he doesn't say anything, for example, like maybe I should call him, or maybe I need my attorney now. I guess it was just a statement at that point. And I think the context builds on this. Again, to move on to kind of bolster my answer, if you look at then 5148, then he basically says, I'll call my attorney as soon as I leave here. So I think he's fully aware that he could have made the call and just chose not to. And then that's when Bugby's discussing like the consequences of all of this, things like that, court dates, consequences of missing them, et cetera, happens at that point. And I think it just adds to it that he knew he had the ability to call, and I think it should attach to any clear request for an attorney, or even an equivocation. Like maybe I should call an attorney, or do I need one? You'll see that sometimes where they'll ask law enforcement, should I talk to an attorney? That certainly would activate here. But I think in this instance, he knew he had an attorney, chose not to call him. I'm going to call him later when I get out of here. On his way out the door, he says that.
Mr. Vonderchuk, Mr. McCabe kind of outlines or alludes to this in his brief, and Justice Tufte's question is appropriate. Is the case law of this court is really derived from implied consent cases. Here, the response to the question, will you take a test, can implicate the defendant, right? So if he says no, he's going to be charged with a crime. Is this limited as a matter of policy to a statutory right to counsel, or is a defendant in this circumstance entitled to a constitutional right to speak with an attorney because their response is going to implicate them in a crime? Is it limited to this statutory right?
I guess in the state's brief, I did argue it's a statutory right, as I would say limited in this particular instance. I think that's only just because that's how the laws have been carved out. And whether the constitutional right can override that, I suppose it's debatable. In my brief, the state's brief, we point out the statutory right. I think it's unique to this circumstance the DUI refusals. But I guess I'm getting back here, I got the statements I've covered. Like I said, I think it's merely a statement. And then like in Bailey, there's an expressed need for an attorney. I don't see that here. If you look at the Bailey case, the Bright Line Rule talks about any sort of express need for an attorney right then. We just don't have that here. So I think in that instance, Mr. Hernandez knew his rights, understood things, and whether or not he knew maybe that it was a refusal charge would be coming from this. Like I said, I don't know that ignorance of that is any sort of an excuse anyway, but he could have executed his rights. And I think just the mere mention of an attorney asks for such an expansion of the law that it wouldn't be appropriate here, because then we have instances where law enforcement would constantly be dancing. And if you've watched the video, like I said, the context is all important. They have quite a conversation, Deputy Bugby and Mr. Hernandez, and even when his statements are taken into that, it just bolsters the state's argument, in my opinion, that there was any sort of active word there, even though the mention of attorney was made. It was strictly in conversation. I would ask the court to uphold the district court's decision here. I can field any questions. That's all I have for argument summary. Everything else is in the brief.
Hearing no further questions, thank you, Mr. Vondercheck.
Thank you.
Mr. McCabe?
Members of the court, Mr. Vondercheck. So one thing maybe to point out is in the Skobodzinski case, if I said that right, at paragraph 29, this court says one relevant factor under this inquiry, the statutory right to counsel, is whether the driver still has time to cure an earlier refusal to take the requested test. And that is so significant here, I think, because we're at the jail, machine's right there. We got 68 minutes at least to take this test out of the 2 hours. And one of the relevant inquiries that the Washburn case talks about is this 2-hour limit, how we got 2 hours to cure the refusal. And again, Washburn dealt with a similar situation where the guy was getting booked. It was well after the initial, declining the test. And this court really took a hardcore look at how Bailey affected the facts of that case and concluded that, in fact, Mr. Washburn activated his right to counsel. So I would argue that in this case, we should defer to giving this person a right to counsel when the consequences are so deep about giving him a crime of refusal, and we know that he's well within the time frame to cure that refusal. He's at the jail. The record reflects the machine's at the jail to take the test, and
Mr. McCabe, we call this a statutory right to counsel. Is it this court's job to give somebody a statutory right? Who gives statutory rights?
Well, the legislature gave the right, and I guess Justice Tufte, the question you had asked is it just towards DUIs? No, it would be applicable to any crime, but I mean,
you've seen my separate writings. You know I don't think this is in this statute. This belongs in 3920 if there's to be a DUI specific right, doesn't it?
Oh, yeah, but we did correct the statute so that it does say now that the accused has a right to speak to counsel. We did fix that.
It says, quote, at the request, quote.
Okay.
The word request, and again, I think it's the fundamental question, is where is a request in this record?
Well, since that statute was read that way back when Coons was first written, and I know Justice McEvers, in one of my cases, wrote about all the cases where this court has long held that there's a right to speak to an attorney based upon that very language, Justice Parr. So, despite the way it says, that's
any
what
of those cases say, but irrespective of no request, you just automatically have that right?
Well, Bailey kind of did away, I think, with wondering word for word what people said, that any mention of an attorney.
Well, the holding, and I'm quoting from the Washburn case that you brought up, but it's quoting Bailey. It says, We hold that if a DUI arrestee, upon being asked to submit to a chemical test, responds with any mention of a need for an attorney, it goes to the findings that were made by the district court, as Justice Barrs pointed out. There was no finding that he requested there was no mention of a need because he already had an attorney. It's the findings. And that goes to the Washburn case also relies on the findings made by the hearing officer, where there was a finding that the driver there asked to speak to an attorney.
I mean, I would argue that as applied to this particular legal issue, this court is reviewing this de novo. I understand the deference to findings of facts, but there wasn't a finding of any fact per se. It was just more of a legal conclusion that I read from the district judge that there wasn't a request for an attorney, not a factual finding per se. I think this court, as a matter of de novo review and as a matter of law, can conclude that based upon the evidence down below, that there was a request under the Bailey standard. So,
Where would you draw that line? If the defendant says, my brother's an attorney, is that a request to speak with an attorney?
well, Bailey says any mention of the attorney. I mean,
In response to a request for chemical testing.
true, but then Washburn says even later on, I mean, Washburn was, or excuse me, Skoboditsky was after the 2 hours. Washburn, I don't know where we were at with time-wise, but it was he was getting booked. It was well after the request and the denial, and Washburn still held that Bailey applied to that mention. Again, I'm not even sure he said attorney, but the hearing officer in this court viewed it as such. So I would, this court, I think, has made clear that you can mention attorney way after being requested to speak to counsel, and the Bailey precedent still applies. So I would ask that this court really take a strong look at this, because it affects a lot of people. I mean, I don't know how many refusals I get in any given week, and it makes my heart break, because they don't know that they should take that gall-darn test. And for those that call me, which are many, then I tell them to take the test, and then they do. But these people don't know. So it's a mess. And anyway, I just hope we can apply a lot of these people to help them out a little bit when they actually mention attorney. So,
If this is a statutory interpretation case, should we read this statute in the context of the DUI statutes that underlie most of your argument here?
well, I think that's the vast majority of case law that this court has dealt with, because it's coming from DUI cases where there's a critical point of speaking to an attorney about taking a test. I mean, most criminal cases, you don't really need to speak to an attorney right away, I would argue.
I have a sort of, this is maybe a little bit outside the scope of what you're focusing your argument on, but a couple of years ago, the legislature removed the statutory bar to admissibility of certain things when the advisories was defective. I may not be describing that quite precisely, but there was a statutory exclusionary rule that got taken out.
Yep.
Is that familiar?
Yes, Your Honor. Yep.
Should that inform us at all about the remedy in a case like a DUI-specific statutory right to consult with counsel, that the legislature has taken out exclusionary rules? It seems you're asking for exclusion here, or some sort of a similar remedy, aren't you?
Well, I was told in my City of Bismarck versus King case, which this court wrote, that I was supposed to file a pretrial motion when there was a right to an attorney. That's right in the case that was written. And so, of course, we did. And so the way I view it, and, the only analogous situation I can come up with is we've got so many DOT cases where the holding is the person refused as a matter of law. This court oftentimes will reverse if there's a violation of the right to counsel or if there's a cure to the refusal. I mean, two separate issues, but this court has dealt with that. So now we're dealing with a criminal case on the charge of refusal, and I think it would be viewed in the same context, that as a matter of law, there is not a refusal. But again, in City of Bismarck versus King, I don't even know if it's in my brief, but that's the case where this court said that one should file, I think I did cite it, but that one should file a pretrial motion if there's a violation of the right to counsel in a refusal case. So it seems to me that it's a legal conclusion as to whether or not there's a refusal. I would add, Justice Tufty, this court's had 2 of my cases now on specifically the refusal cases out of the administrative process, where the court, even though the exclusionary rule didn't apply to a refusal, this court as a judicial remedy has concluded both on the screening device and on the chemical test that if the implied consent advisory was not read in full, that it was not a refusal. And that still exists today, that case law, at least the last one on the screening test, even after the change when the legislature removed that exclusionary rule, so.
But the exclusionary rule still applies to implied consent hearings by its plain terms.
Only in refusals.
Correct.
Yes, yeah, because of the judicial remedy created in those 2 cases I had. Larson and, well, anyway, I can't remember the other one, but anyway, thank you very much. Oh, Alvarado, that's what it was, Alvarado and Larson, so, thank you, Your Honors.
Thank you, Mr. McCabe, for your argument this morning, as well as yours, Mr. Vondercheck. This case will be taken under advisement, as all cases are, and the court is adjourned until 10:45 a.m.